There are 6 documents that every American homeowner over the age of 60 needs to complete, yet most never file them. And when they pass away, those missing forms can cost their children the home. I'm going to walk you through each one, the exact amount of money each can save, and the correct order to submit them. The 5th document on this list is the one that 9 out of 10 seniors never even hear about until their family is already sitting in probate court watching a judge decide who receives their parents' house. And we will cover that one in just a moment. But first, you need to understand why this situation exists in the first place. The probate system in the United States was not built to protect families. It was created to generate revenue for state courts and fees for the attorneys who operate within it. Because of that, every year, hundreds of thousands of families across America lose tens of thousands of dollars, sometimes even the full value of a family home, simply because the system's creators never informed them about the 6 documents that could have prevented it. Most of these forms cost under $200 to file. Some of them are even free. But if you are unaware they exist, the system takes money that should go to your children, and after you pass, there is nothing your family can do to stop it. Here are the 6 documents in the exact order you should file them. The first one alone can be the difference between your children paying $20,000 or paying nothing at all. It is known as a transfer on death deed, often called a TOD. This document has one simple purpose, but it is the most important one on this list. It lets you name who will inherit your home immediately upon your death without the property ever going through probate court. Here is why that is so important. The average probate case in the United States costs families between 3% and 7% of the total estate value. That means on a home valued at $300,000, your children could end up paying between $9,000 and $21,000 in court costs, legal fees, and executor expenses before they even receive ownership of the home. But the money is not the only issue. In some states, the probate process can take anywhere from 9 to 18 months to complete. During that time, the home cannot be sold, refinanced, or even cleared out. Property taxes still have to be paid. Insurance must remain active. If there is a mortgage, those payments continue as well. All of these expenses come directly from your children's pockets, while they wait for court approval just to access their own parents' property. A transfer on death deed removes that entire process. You file it once with your county recorder, and on the day you pass away, ownership of the home transfers directly to the person you named. There is no court process, no attorney fees, and no waiting period. This form is available in about 30 states. You can check if your state allows it by searching Transfer on Death Deed, along with your state's name. The filing fee in most counties ranges from $20 to $60, but the Transfer on Death Deed only works if you file it before you die. Most people learn about it too late. That is why this is not something you should delay until next year. The second document is one the federal government would rather you did not know about. It is called a ladybird deed. This option is only available in 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. If you live in any of these states, pay close attention over the next 60 seconds because this single document can protect your home from a threat that destroys families every single day in this country. Here is what it does. A ladybird deed allows you to maintain full control of your property during your lifetime, including the ability to sell it, refinance it, or rent it out. But the moment you pass away, the property automatically transfers to the person you named on the deed. It works very similarly to a transfer on death deed, with one major difference. A ladybird deed protects your home from Medicaid estate recovery. The Medicaid 5-year look-back rule in another video on this channel, but here is the simple version. If you apply for long-term care Medicaid in your later years, the federal government has the legal authority to return after your death and force the sale of your home to recover every dollar Medicaid spent on your care. For a typical 3-year nursing home stay, that could mean between $240,000 and $360,000 taken from your estate. This is how families lose everything. The ladybird deed removes your home from your estate immediately upon your death. As a result, there is nothing for the government to reclaim. Your children receive the home completely free, even if you spent your final years on Medicaid. However, the Ladybird deed must be filed and recorded before you ever apply for Medicaid. If you wait, the look-back rule eliminates the protection. That means if you live in one of those 5 states and own a home, this is something you should discuss with an estate attorney this month, not next year. By the time you need it, it will already be too late. The third document is the one that saves families more money than anything else on this list, yet it is also where people make the most costly mistake. It is called a revocable living trust. Setting up a trust costs more than the first 2 documents, typically between $2,500 and $3,000, depending on the attorney. But here is why it is worth it. When you place your home into a revocable living trust, the property is no longer in your personal name on paper. It belongs to the trust. You still retain complete control. You can sell it, refinance it, or move whenever you want. Nothing about your daily life changes. But because the trust technically owns the home, it is no longer part of your estate when you die. That means it bypasses probate entirely. On a $400,000 home, this single step can save your family between $12,000 and $28,000 in probate fees alone. But a trust does more than just save money. It allows you to give clear instructions for what happens to the home after you are gone. If you have 3 children and one lives in the home while the others want to sell, the trust can clearly define what should happen. If you want your spouse to remain in the home for life and then pass it to your children afterward, a trust can handle that. If you want to protect the property from a future divorce involving one of your children, a trust can do that as well. A will cannot provide these protections. A will is reviewed in court, and a judge makes the decisions. A trust is private. It avoids the court system entirely and follows exactly what you specified. But here is where people ruin everything they just paid for. The most expensive mistake families make with a trust is creating it and then failing to transfer the home into it. This process is called funding the trust. If the trust exists but the deed was never updated, the trust has no effect. The home still goes through probate. Every dollar spent setting up the trust is wasted. That is why, after creating a trust, the very next step is to file a new deed, transferring ownership of the home from your name into the trust's name. If you skip this step, the trust becomes useless. We are now halfway through the list, but the 5th document is still coming, and it is the one almost no one knows about. It is also the one that can save your family the most money, yet it has the shortest window to act. Stay with me. The 4th document is an updated will that includes clear language regarding your home. If you die without a will in the United States, the state decides who receives your property. This is known as dying intestate, and the rules are often very different from what people expect. In Texas, for instance, if you pass away without a will while married, your spouse may only receive 1/3 of your separate property. The remaining 2/3 go to your children, even if they are from a previous relationship and have no connection to your current spouse. In California, if you die without a will and have children, your spouse may receive only 1/3 or 1/2 of community property, depending on the situation. In Pennsylvania, your spouse receives the first $30,000 and the rest is divided. These rules differ by state, but the pattern is consistent nationwide. The state assumes it knows best how to divide your property, and unless you have a written will stating otherwise, the state's rules apply every time. The solution is simple. A basic will costs between $200 and $800 when prepared by an attorney. Some online options offer cheaper versions under $100. However, if you own real estate, it is better to avoid generic online versions because the wording must match the laws of your state. But here is what most people overlook, and it is what causes serious family disputes. A will must be updated whenever there is a major change in your life. If you created your will decades ago and have not reviewed it, the information is likely outdated. Your spouse may have passed away, your children may have gone through divorce, you may have grandchildren now. The executor you named may no longer be alive. Because of this, every will should be reviewed every 5 years and whenever a significant life event occurs. An outdated will can be worse than having none at all, because families may end up in court arguing over which version applies. While that happens, the home continues to cost money. Now we reach the fifth document. This is the one almost no one knows about. It is called a durable power of attorney for finances. This is the form that 9 out of 10 seniors fail to complete, and it is the one that ends up costing families the most. If you only complete one document after watching this, make it this one. Here is why. A durable power of attorney allows you to appoint someone you trust to manage your financial matters if you become unable to do so. If you suffer a stroke, develop dementia, or are hospitalized for a long period, this document enables your spouse or child to pay your bills, manage your accounts, and most importantly, take care of anything related to your home. Without this document, your family has no legal authority to act on your behalf. They cannot access your accounts, pay your mortgage, or handle your affairs. Instead, they must go to court and request that a judge appoint a guardian or conservator. This process is called a guardianship proceeding, and it typically costs between $3,000 and $10,000 in legal fees just to establish. After that, the appointed guardian must submit yearly reports to the court, which can cost an additional $2,000 to $4,000 annually. But the biggest issue is not the cost, it is the time. A guardianship case usually takes between 3 and 6 months to complete in most states. During that time, no one can pay your property taxes, approve repairs, sell the home if necessary, or handle financial responsibilities. Meanwhile, the bills continue. Mortgage lenders do not pause payments just because a case is pending. As a result, families lose homes to foreclosure during guardianship cases every year. And all of it could have been avoided with one simple document signed in advance. A durable power of attorney typically costs between $100 and $300 and takes about an hour to complete with an attorney. But here is why it is urgent. It must be signed while you are still mentally capable of doing so. Once a doctor questions your mental capacity, you can no longer sign it. Sign it from a hospital bed. Your children cannot sign it on your behalf. After that point, the only option left is going through the courts, and by then, the damage is already done. The sixth and final document is your homestead exemption application. This is the one costing you money right now. Every month you do not have it filed. Nearly every state offers some form of homestead exemption for homeowners, but the rules and benefits vary widely. In Florida, for example, it can reduce the taxable value of your home by up to $50,000 and limit how much property taxes can increase each year. In Texas, as of 2024, it can reduce the taxable value by $100,000 for school taxes alone. The yearly savings differ by location, but most senior homeowners save between $1,000 and $3,000 annually. Over 20 years, that adds up to $20,000 to $60,000 kept in your pocket instead of going to taxes. But here is what many people do not know. In many states, this exemption is not automatic. You must file an application with your local tax assessor, and you only need to do it once. After that, it stays in place as long as you own the home. The application is usually free and takes about 15 minutes to complete. Many states also offer additional exemptions for seniors starting at age 65, adding even more savings over time. Yet most eligible homeowners never apply because they are never told about it. You have to know to ask, and now you do. Here's what you should do this week. First, locate your home's deed. It may be in a file, a safe, or available through your county's online records. Second, list which of these 6 documents you already have and which ones you are missing. Third, for any missing document, search its name along with your state to learn the requirements. Review the first few results. Fourth, contact an estate attorney in your area and schedule a 1-hour consultation focused on protecting your home. This will usually cost between $200 and $400. The attorney can guide you on which documents apply to your situation based on your state laws, family structure, and property value. Fifth, do not delay. Each of these documents has a limited window to act, and those windows close the moment something happens to you. Once you are hospitalized, once the court becomes involved, or once the state steps in, these documents can no longer help you.